Welcome to Vanik Smart Live YouTube class. I'm SK Raut. Here is an initiative of Vanik for the aspirants of Odisha Civil Service Examinations. This session is meant for Odisha Civil Service Examination Preliminary 2020, which is going to be held next week. So we have brought some BST, very similar questions for all of you to discuss on Indian polity. We had already a session on previous year questions on Indian polity some days ago. Now we are bringing the BST questions that were conducted at Vanik premises. And this will be also helpful for all of you because it has been prepared by expert developers and they will be definitely important for your upcoming examination, some of them. Okay, so we start the session. Okay, thank you very much. Now that Ocs Prelim 2020 BST 1 questions we shall be discussing. Okay, so look at the first question. After the formation of Bharatiya Janata Party, who became its first president? So, first president was Atal Bihari Vajpayee and it was established in 1980. BJP was established in 1980. So, that is 1980. It was earlier known as Jana Sangha. So, BJP had its origin in 1980 and A.B. Vajpayee became the president. Now it is headed by J.P. Nadda. Okay. So that is the political party and BJP is a national political party in India. Then next question number 2, in which of the following cases the Supreme Court observed that Central Bureau of Investigation is a caged parrot? In which of the following cases the Supreme Court held that CBI, which is the apex investigating body in India, is a caged parrot, means that it doesn't have the required independence. So R.M. Lodha, Chief Justice of India, mentioned it in Coal Gates Calm in 2013. So Coal Gates Calm 2013 is the answer. And because the coal license were given without competitive bidding by the government, hence the scam arose, and it was in 2013, and Justice R.M. Lodha termed during the judgment on the case law that the CBI did not act in the way it is expected. So he mentions it as a what? As a caged parrot because it doesn't have any independence as the court, apex court interpreted. So that is option D. Okay. Now question number 3. Who notifies the alteration in the limits of block Jilla alteration? Who notifies the alteration limits of blocks and Jilla Parishad? That is obviously the State Election Commission. State Election Commission. That B. The member of the Panchayat Samiti are. Panchayat Samiti is, as you know, is the second tier in the hierarchy and it is located at block levels, and the members of Panchayat Samiti are elected indirectly by the people of the village funds. That is directly elected by the people. The members are directly elected by the people. But here you must have remembered that the chairperson is indirectly elected by the whom? By the members of the Panchayat Samiti. That is the things about number 4, the members of the Panchayat Samiti are directly elected. All the members, not only the Panchayat Samiti, but also the members of the Grama Panchayat and also the Jilla Parishad, they are directly elected by the people, except the chairpersons. Okay, so answer is C. Answer is C. Okay, now we shall move to the next question, question number 5. Is it visible to all of you? Which one of the following committees is not concerned with Panchayat Raj institutions? Which of the following committee is not concerned with Panchayat Raj institutions in India? That is Santanam Committee, V.N. Gadgil Committee, Ashok Mehta Committee, or Balwant Rai. Santanam Committee was appointed in 1962-63. That is on anti-corruption, on prevention of corruption, and it is the body which had recommended for establishment of CBI and CBC. So Santanam Committee is very important so far as polity in India is concerned, that it recommended for establishment of CBC and CBI. Okay, so it was a premier committee on prevention of corruption in India. V.N. Gadgil was in the year 1989, and Ashok Mehta was 1977, and Balwant Rai was 1957. In fact, it was the first post-independent committee on Panchayat Raj. Okay, that is the things. So, question number 5, answer is A. Answer will be A. Yes. Now, question number 6. Question number 6. Which of the following is not a constitutional body? As all of you might have prepared well, but constitutional body is a body which is mentioned in the Constitution of India. So if you look at the body, Finance Commission is mentioned in the Constitution of India. It is in Article 280. Article 280. Niti Aayog is not a constitutional body, rather it is an executive body or extra constitutional body which was formed on 1st of January 2015, replacing the erstwhile Planning Commission. It is an executive body, extra constitutional body. So Union Public Service Commission is an executive, that is constitutional body under 315, it is 3 to 4. So hence the answer will be B. Okay. Then your, just a minute. Then your question number 7, that the Government of India recently approved 50 crores to develop an all-weather ROPAX, road on, road off, that is jetty, that waterways will be made, ROPAX. And ROPAX is that is a measure by the government of Odisha. The answer will be Odisha. So the answer will be Odisha. Let us see the option D. Option D will be there. ROPAX is a jetty, that is a ferry waterways will be prepared by the government of Odisha from Dhamra to Talchur, that is in Kendrapada and district and Bhadra district will be linked. So Odisha. Answer will be Odisha. D. Question number 8. The system of proportional representation. Very important question. The system of proportional representation as an electoral mechanism ensures majority rule majority rule, yes, obviously a majority rule, but in direct election or universal adult franchise, the fast past, fast post system that is there is also majority rule. Stability in government, that is not concerned. Common political thinking, it's not a option at all. representation of minorities, because representation of people's proportional system based on the representation of the minority section or the means the minuscule section of the society, so that the government will be a completely representative body. In India, for the election of the president and others vice president, this system is followed, but that is not exactly proportional representation. It is alternate voting system, alternate system, but proportional representation is followed in Ireland and other countries where a number of posts are filled up. But in India, proportional system of representation is followed for only one post at a time, that is president. So it is not exactly proportional system, because it is not, it does not follow the required elements of this system, whatever it may be, but this election is called, presidential election is also called proportional representation by means of single transferable vote. So here answer will be D, I think. Here answer will be D, representation of minorities. Then select the correct chronological order of the following. So that will be Goloknath case. Goloknath case will be 1967, and here 1973 Kesavananda Bharati case. Minerva Mill case 1980, and here 1950 A.K. Gopalan case. In Goloknath case and versus State of Punjab, the Supreme Court held that fundamental rights are immutable and transcendental. In Kesavananda Bharati case is a very important, very important case so far as political system of our country is concerned. It is the largest, it was headed by largest bench, 13 judges bench, and it was on fundamental rights. But during the intercourse, during the judgment, the Supreme Court made many important judgments. So therefore it is a very important case. It is related to the amendability of fundamental rights under the right to property and so other matters. Minerva Mill case is also brings a solution to the conflict between DPSP and fundamental rights. It says that both constitute the bedrock of Indian Constitution. Hence it is important, because it has not only given primacy to fundamental rights but also to DPSP. It is the only case deals with. A.K. Gopalan case is all about a particular section in IPC and based on Article 21, that Preventive Detention Act 1950. On that restrictions or detentions under Preventive Detention Act 1950 were challenged in A.K. Gopalan case. So the chronological order will be D, A, B, C, D, A, B, C. Okay, let us see what is there. D, A, B, C. Okay, so D, A, B, C. Yes, the answer will be D, A, B, C, C. Answer will be C. Okay, so answer will be C. Answer will be C, sorry. Answer will be C. Just a minute. Answer will be C. Question number 9, answer will be C. Okay. So that is the things of, okay. So question number 10. Question number 10. Yes, question number 10. Which of the following Amendment Act of the Constitution deleted the right to property from the list of fundamental? Very easy question for all of you. So that is 44th Amendment Act. 44th Amendment Act 1978. Answer will be 44th Amendment Act 1978. That right to property was abolished. And with regards to 37 is related to provision of legislative assembly in panchayats, legislative assembly in Arunachal Pradesh. in Arunachal Pradesh, Legislative Assembly in Arunachal Pradesh. Okay, so these are the things. 42nd is called Mini Constitution of India. Mini Constitution of India. Okay, so these are 38 amendment is related to emergency and others. 38 Amendment Act 1975. So answer will be C. Okay, so that is number 10, answer C. Okay, now move to 11. Question number 11. Consider the following statements. The Rajya Sabha, that is yes. The Rajya Sabha has no power either to reject or amend a money bill. That is right. Okay, Rajya Sabha doesn't have the power to amend or reject a money bill. That's right. Rajya Sabha cannot vote on demand for grants. Demand for grants is a stage followed in the budget session. While during the passage of the budget, demand for grant is also a final, approximately a final stage, and they are all money bills, so they are never moved to the Rajya Sabha. Rajya Sabha doesn't have the power to vote on the demands for grants. It is exclusive privilege of Lok Sabha. Rajya Sabha cannot discuss annual financial statement, but it can discuss. Rajya Sabha cannot discuss, no, Rajya Sabha can discuss. So answer will be 1 and 2 only. 1 and 2 only. It can discuss the budget, but it cannot vote, it cannot bring any amendment. So answer will be 1 and 2 only. B. Got it? Am I clear? Okay. Now question number 12. After the formation of Bharatiya Janata Party, who became the first president? The first president became, it is repeated perhaps, B. Atal Bihari Vajpayee. Atal Bihari Vajpayee became the founder of the Bharatiya Janata Party, and it became the first president in 1980. Then BST2, the distribution of powers between the central and states in the Constitution of India is based on which of the following? The distribution of powers between the central and states. That is called the what? That is called the division of power or federal scheme. So federation. So which act provided for federal scheme? Obviously 1935. So 1935 is the answer. 1935 Government of India. So BST2 question number 1 answer is C, that it provided for distribution of powers between center and states. Okay, next number. In a federation established by the Government of India Act 1935, residuary power were given. What do you mean by residuary power exactly? Residuary power means the powers that are not mentioned in the division lists. So the power that are left not to be included in neither in union list or nor in state list and concurrent list. So that is called residuary power. In Government of India Act 1935, the residuary power was to be vested in the Governor General, in the Viceroy, but Governor General of India. So that was an irresponsible executive. But today, under the present political system in India, the residuary power is vested in the central government. Okay, so answer will be B, residuary power vested. Very important question. Okay, B. Then which of the following statement is true? The classical federal form of government in United States, which of the following is true? Achha. The classical federal form of government is in United States of America. That is a classical form of government because it is a typical federation. All the federal characteristics of a true federation are found in are prevalent in USA. So that is true. Let us see other options. The Government of India is more federal than unitary. That is not true because it is rather to say ki more unitary than federal. So it cannot be said ki more federal than unitary, because we contain maximum number of strong points regarding unitary provisions, hence it is called, as you know, federal in form, unitary in spirit. So that is wrong. Government of France is of federal form. It is both, not exactly federal form. Prime Minister of Pakistan is directly elected by the people. No, okay, that is not a case. That is exactly parliamentary system prevails with some deviations. So that is not wrong. So answer is A. Then I have given you the updated version, union list, state list, concurrent basing upon certain books, because the lists are confusing always. Many internet, if you browse through internet, you will find different answers. But make confirm that I have received some authentic books from that. So union list is 98 after GST, state list 59, concurrent list 52. But if you get any updated version, be confirmed. So answer will be A, B, C. A, B, C. 1A, 2B, and answer C. So answer will be A, A, B, C. I will show the answer. Answer will be A. Okay, all are correctly matched. So answer will be A, B, C. It's gone. Okay, then the question number 5, BST 2. The goal of Constitution to secure or assure all its citizens. What is the goal of the Constitution? And where is goal of the Constitution is mentioned? Goal is mentioned in preamble. So let us see what is mentioned in preamble. Justice, social economy mentioned, liberty of thought expression mentioned, equality of opportunity mentioned, dignity of individuals. By assuring the dignity of individuals and unity and integrity of the country. So all the above are mentioned in are the goals of the Constitution. D. One of the implications of equality in society is the absence of. What is the meaning of equality? Equality means absence of special privileges for any section of the society. That is the buzzword. That is the essential characteristic of equality. So in equality you will find that there is no privileges. Yes. So 5D and 6 will be privileges. Okay. Yes, that is right. Okay. So answer will be A. Privileges. One of the, mind the language mentioned in the question. One of the implications of equality in society. So equality of meaning, that is absence of privileges. Okay. Now, okay, then justice, economic, social and political. So it is not mentioned political. Okay, Akash, yes, you are right. Justice, social, economic and political, but it is not mentioned exactly. It has left the things. So we have to take the option right. Okay, because as social, economic justice are also assured. Okay, then one of the implications gone. Now we shall move to 7. The parliamentary form of government was first introduced in which country? Parliamentary form of government was first introduced in which country? What do you think without looking at the option? Yes, that is UK. UK will be the answer. Okay, UK will be the answer. Parliamentary form. What was the question? Parliamentary form was introduced in which country? So answer will be, that is A. Great Britain is the mother of parliamentary form of government. That is called Westminster model. Okay, then when was Citizenship Act passed recently? When was Citizenship Act passed? Means came into effect. Better to change the question. When did Citizenship Amendment Act came into effect recently? That is 11 December. 11 December 2000 passed, then it came into effect on 11 January. Okay, so it was passed on 11th December. 11th December 2019. And what happened under Citizenship Amendment Act? What happened under Citizenship Amendment Act? what happened under Citizenship Amendment Act? That some 6 major religious groups were given citizenship in India. They were given citizenship in India. They were from which country? They were from Afghanistan, Pakistan and Bangladesh. They are granted, only Muslims are excluded from this list. So that is a controversial, that became controversial for a certain period of time. Many states resisted it. So it was amended for the 9th time. Citizenship Act was enacted in the year 1955. It got amended for the first time in 1957. So far, the Act has been amended for 9 times, including 2019. Okay, so get an average idea about all these things. When you get a question, don't skip it, just looking at its answer. Rather, made an analysis, what can be other questions related to the questions. Okay, then we shall discuss question number 9, BST 2. What is the name of the new redressal platform launched by the Ministry of Shipping? That is SORUT. SORUT, that is Society for Affordable Redressal of Disputes. Society for Affordable Redressal of Disputes, SORUT course. So related dispute resolution mechanism has been adopted by Ministry of Shipping, that is popularly known as SORUT. And the full form of SORUT is Society for Affordable Redressal of Justice. Society for Affordable Redressal of Disputes. So that is launched recently by Ministry of Shipping. Okay, SORUT sports. So next, question number 10. Consider the following statement. Parliament of India can place a particular law in 9th schedule of the Indian Constitution. You must have an idea that 9th schedule was added by First Amendment Act 1951, and 9th schedule contained land reforms and other related provisions. Later 9th schedule was kept also, like from the initially when it was established, it was kept beyond judicial review, and so many governments, successive governments took undue advantage of this protective chamber. Hence, in Kesavananda Bharati case 1973, the Apex Court held that any act provision entered into the 9th schedule after April 24, 1973 will be judicially reviewed. Until April 24, 1973, all the acts that were entered in 9th schedule are protected. That means they cannot be judicially reviewed. So first point is right. Parliament of India can place a particular law in the 9th schedule of Indian Constitution. Yes. Next, the validity of law placed in 9th schedule cannot be examined by any court or no judgment can be made on it. That is wrong, because now the thing can be done. Now any act enter into the 9th schedule can be judicially reviewed, examined by the Apex Court. Hence, only one, statement 1 is correct. Statement 1 is correct. Okay, so answer will be A. Next, yes, 10A. Next, so 11. With reference to Indian history, the members of the Constituent Assembly from the provinces. So, as you are on the last stage of our preparation, these are very rudimentary questions that you can better answer. But let me share you what I think about this. that Constituent Assembly contains members from native states and provinces. Here provinces means the governor's provinces and the commissionerate provinces. There are about 296 posts, 296 seats were to be elected at the initially. So that will be elected by, they were elected not but directly by the people. They were elected, they were to be elected indirectly by the members of the provincial legislative assembly in each state. So that was an indirect election obviously, and the princely states members were to be nominated. So hence it is called the Constituent Assembly composed of both nominated and elected members. So answer will be, that is answer will be elected by provincial legislative members. So C, answer will be C. Okay, question number 11, answer is C. Then 12, the objective of Ilbert Bill that was passed in 1983, it was became a 1883 Ilbert Bill. You must have gone through it in your Modern India paper. Ilbert Bill was a controversy and it had the ambition 1883, it had the objective that to bring Indians and Europeans at equal status as far as the penal jurisdiction of court was concerned. That means the case, Indian cases and European cases should be decided by the same judge. There would be no different judges, different penal code for Indians and Europeans, but the bill was not, the bill did not see the light of the day, it did not become a reality, it became controversial and last moment it was rejected. So that is answer is A. A, answer is A, Ilbert Bill. Answer is A. Then question number 13 of BST 2. Which of the following is our principal features of the Government of India Act 1919? We are talking about Government of India Act 1919, principal features. The introduction of diarchy in the executive government of the provinces, yes, that is right, because diarchy was introduced in Government of India Act. It was a division of executive powers of the governor, because it divided the powers of the governor from, that is from as into reserved and transferred category. So that will be right. Introduction of separate communal electorate system for Muslims, it was not there because Government of India Act 1919 extended the separate electorate system for Sikhs, Indian Christians, Anglo-Indians and Europeans, because Indian Council Act 1909 had already introduced communal electorate system for Muslims. Then that will be wrong. Then devolution of legislative authority by the center to the provinces. Yes, certain legislative authority, budget making and others were transferred to the 1919 as a mark of federal characteristics. So it introduced the federal things in an indirect way, devolved some power to the provinces. So answer will be 1 and 3. 1 and 3, yes. C. Answer will be C. Okay. So yes, that will be C. Now we shall move to the VST 3. Okay, VST 3. Which one of the following articles of Indian Constitution has not so far been used? 6 is related to presidential conditions. It is related. 352 is national emergency. It has been implemented. 356 is about state emergency. It has been for several times. But Article 360 is about financial emergency. It has not been implemented so far. So hence the answer will be D. While dealing with complaints of violation of human rights by the members of the armed forces, The commission either on its own motion or on receipt of a petition will inquire itself, give direction to the concerned police officer to inquire, seek a report from the central government. With regards to armed forces, the human rights can investigate the NHRC, National Human Rights Commission, but it has to seek the permission of the that is the central government. So that is a condition C. Okay, so question number 2 answer is C. Okay, next question number 3, which with reference to pardoning power of the president, and governor, consider the following statements. The president has pardoning power against punishment of court martial. Yes. The president has the pardoning power. Governor does not have the power to pardon death sentence. Article 161 mentions, and president is 72 articles. So they both have the power to grant pardon, commutation, remission, respite and reprieve in order to rectify a judicial error. Both have got their powers, but the governor does not have the power to pardon a death sentence. He can grant other mechanism like your commutation, remission, but not pardon. But the president has the pardoning power against, so that will be two only, one only. One is the right answer, one is the right, two is not right. So question number 3, VST 3 will have answer A. Now question number 4. Okay, question number 4. With reference to election of the President of India, consider the following statement. Okay, the value of the vote of each MLA varies from state to state. Yes, that will vary because smaller population. For example, in Sikkim, the value of votes will be around 7-8, but in case of Uttar Pradesh, there will be more than 200. So therefore, the value of vote each MLA varies from state to state. And you know how the value of vote of an MLA is estimated, that is total number of total population of the state divided by the number of elected members into 1/1000. So in this way, the value of votes of MPs, MLAs are measured. So it varies from state to state because of variance in the population of the states. So that will be right. Then the value of votes of MPs of Lok Sabha is more than the value of votes of MPs of Rajya Sabha. That is wrong, because the calculation is made by dividing all the value of votes of all MLAs divided by total elected members. So at a time calculation is made, hence the member of Lok Sabha and Rajya Sabha has equal value, votes have equal value. So that will be only only one, phone number only 1, A. Electoral college of the election of the president, that is mentioned in article 55, method of election, and 54, election. So electoral college of the election of the president consists of, that is all the elected members of Rajya Sabha, no, all elected members of Rajya Sabha, that is a part, all members of the state legislative assemblies. Okay, then let us see what is there the option. Okay, all the elected members of both the houses of parliament and the elected members of state legislative assemblies. So as you know, that will be the answer D. So the electoral college of the president consists of all the elected members of both houses of parliament and elected members of both the state legislative assembly. Then which of the following does not fall within the purview of Article 21 of the Constitution? Medical aid to injure by a doctor, sexual harassment. 21. Article 21 is a composite articles, and it is mentioned in fundamental rights part. Okay. So therefore, there are very inherent rights that is provided. Okay. So the question is that is what is not mentioned in the purview of Article 21 of the Constitution? Medical aid to injure by a doctor, sexual harassment of women at workplace, pollution of the quality of water. Capital punishment is not dealt with. They are all dealt with, means that they are provided. Article 1 implies that a person should be free from pollution, water pollution. It is his fundamental right under Article 21 according to the interpretation of Supreme Court. But capital punishment is not mentioned. So that is D. That is the question, I think. Okay. So question number 6 is D. Then what is meant by rule of law? What is meant by rule of law? So that is a question. One act for all and one judiciary for all. One act for all and one state for all. One state for all and one judiciary for all. All acts for one judiciary for all. So that is confusing. You are confusing options. So only the option B seems to be right. One act for all and one state for all. State means the entire country, political concept. Then a parliamentary system of government in which all political parties in the parliament are represented in the government. Never. The government is responsible to the parliament and can be removed by it. That will be a viable option. Government is elected by the people, can be removed by them. No. Government is chosen by parliament but cannot be removed by it before completion of fixed term. So the answer will, best option will be that government is responsible to parliament. Parliament means collectively responsible to Lok Sabha. So that is also a thing. Option is D. So very good question. Parliamentary, that is executive responsibility to parliament, Lok Sabha. The council of ministers headed by the prime minister are, yes, collectively responsible to Lok Sabha, individually responsible to president. So question number 8, answer will be B. Then we shall move to question number 9. Which one of the following is not embodied in the preamble to the Constitution of India? So liberty of thought is mentioned, economic liberty is not mentioned, so that will be answer B. Answer will be B. The preamble to the Constitution of India is a part of Constitution, has no legal effect. Not a part of the Constitution has no legal effect. A part of the Constitution has the same legal effect. No, a part of the Constitution but has no legal effect independently of other parts. So what will be the answer? What will be the answer to these questions for your information? A part of the Constitution. It is considered a part of the Constitution. It is considered a part of the Constitution for the first time in Kesavananda Bharati case 1973. Preamble considered a part, but preamble does not have any legal effect like other parts. It cannot be considered as a model of judgment, as a source of judgment, or judgments of Supreme Court cannot be based on that, because they are not source of power. It is a static part, but it is considered a part, hence it can be amended. So it is a part of the Constitution but has no legal effect independently of other parts. That will be D. D will be the answer. Number 10. Okay. Next point 11. The right of government to impose taxes to impose taxes and fees is provided in which of the following schedule of the Constitution? Right of the government to impose taxes and fees. In 6th schedule there is state government that is mentioned about the Assam, Tripura and your Meghalaya and Mizoram. So, tribal areas concerned. IX is about land reforms and others. XI is about the what? About the panchayat list, and your that is 7th schedule is about the division of power. So, hence there are certain points, subjects that are assigned to union and states to deal with. So, that may be the answer, that taxation B. Who is authorized to suspend or remove chairman and members of joint public commissions? Joint public commission, public service commission was provided in Government of India Act 1935, but they are not mentioned in the Constitution. Rather, it is left to the Parliament to establish a joint public service commission in India. Whenever joint public service commissions are established, it is the President who deals with all the matters related to JPSC. So, that is also a point to be remembered. The answer will be C. Answer will be C. President can that do the things. Next, question number 10. What is the term of Chief Election Commission? Very easy. That is the answer is 6 years. 6 years or 65 years, whichever is earlier. So, answer will be C. So, question number 10 will be, answer will be what? Answer will be, that is C. Answer will be C, 6 years. Okay. So, answer will be 6 years. 6 years or 65 years, whichever is earlier. Okay. Under which article of Constitution a state government can pass a resolution to form a legislative council in the state? Legislative council is an optional provision of the states. So, it can be established by a resolution moved in Article 169. Legislative council is not a permanent provision in the states. Rather, a state can opt for any kind of legislative council if it wants. It can create, abolish. First it will pass a resolution, then the resolution will be approved by Parliament, then a state legislative council will be formed. So, that is under Article 169. Okay. So, there are many, about 6 states which are having state legislative council at present today. Okay. So, you must have idea about that. Legislative council is a merely dilatory chamber. It does not have such extensive power, even it cannot be compared with Rajya Sabha in powers and privileges. Then BST 4, who can dismiss the governor from the office? That is very easy question. President can remove a governor, and remember that the removal of the governor is not mentioned in the Constitution. Okay, Punchi Commission that was appointed on center-state relation had recommended that governor should be removed by state legislature through a resolution, but so far nothing has been amended or provided. So, he holds office during the pleasure of the President. He can be removed at any time by the President. Okay, so number 1 is the answer. Answer is B, C. Number 2, Parliament may legislate on any subject of the state list. There are different circumstances under which a Parliament can legislate on state bills. So, one of them is during national emergencies, Article 250, and if a Rajya Sabha passes a resolution to that effect, then Article 249. So, there is, let us see the option, Parliament may legislate on state list. There is assent of the President, no. resolution thereof has been passed by the Council of States. If Rajya Sabha passes a resolution, then the Parliament can make a legislation on the state list. That is one of the circumstances in which Parliament can legislate on the state list. Okay. Then which article of Indian Constitution says Parliament has the power to make laws on any matter in the state list if a proclamation of emergency is mentioned, is in operation. So that was I was telling you, article B, that is article 250, answer is B. That is very important. During national emergency, under article 253, the Parliament can legislate on state list. But remember, during national emergency, the state assemblies are not dissolved. They are in operation, but Parliament assumes more power and more things under article 250. So that is, answer will be 3, VST 4, question number 3, answer will be B. Then reservation of seats for scheduled tribes in the Lok Sabha does not exist in the state of. There are many states which doesn't have the reservation, SC/ST reservation, especially the northwest and western states, Punjab, Haryana, Uttar Pradesh. Here the answer will be Kerala and Tamil Nadu, they don't have ST reservations. So total ST reservations is not found in that is Kerala and Tamil Nadu will be the answer. Kerala and Tamil Nadu. Baki browse through the list, you will find that many states do not have ST reservation. Some states have larger ST reservation in Parliament. For example, Odisha has 5 and Madhya Pradesh has the largest. Some states have combined, some states have only SC reservations, some states have only ST reservations. So that is why the question is. So check the list and also get more idea about this thing. Okay. Now question number 5. Which of the following is not true? The president has, okay, number 5. The president or governor is immune from legal action for official acts, article 361. The presidents and governors cannot be questioned. No court can compel a governor to perform any duty, that is also true. A 2 months notice in writing must be delivered to governor beginning civil proceedings. Courts are empowered to inquire the advice tendered by the ministers to the president or governor. No. No judicial review can be made. Whatever advice is tendered to the president or to the governor, that cannot be inquired. So answer will be D. Okay, so that is the things about question number 5, that the governor, the advice tendered by the ministers cannot be examined in the court. So next 6, duties levied by the union but collected and appropriated by the states. Tax devolution or taxation division is made on the basis of the 7th schedule. So there are certain tax which are levied by the union but collected and appropriated, means consumed by the state. So that will be the stamp duty perhaps, stamp duty. Let us see the option. Yes, stamp duty, option C. That will be C. Consider the following statements. Council of Ministers in the centre shall be collectively responsible to Parliament. Here collectively responsible to not to Parliament but to Lok Sabha exactly, because if it is Parliament then it will be both Lok Sabha and Rajya Sabha as far as my knowledge is concerned. The Union Minister shall hold the office during the pleasure of the President of India, that is correct. The Prime Minister shall communicate to the President about the proposal for legislation under Article 78. So, let us see the options. I think 1 is not correct. So, what is the option first? 1 is not correct. So, that is, to me 2 and 3 will be the answer. 2 and 3 will be the answer. B. Okay. So, Council of Ministers are not collectively responsible to Parliament, that is to the Lok Sabha. Exactly. So, exactly not mentioned. It means that it will be responsible to both the houses, not that. Therefore, I rejected the option. Okay. Number 8, for election of Lok Sabha, a nomination paper can be filed by. For election, how many seats are elected? How many seats are meant for election in Lok Sabha? 500? Yes, 543. So, who can contest? Anyone residing in India? No. A resident of the constituency from which the election is to be contested? No. Any citizen of India whose name appears in the electoral roll of the constituency. That means a person who is registered as a voter in India is only eligible to vote, is only eligible to contest or vote, otherwise he cannot. So, nomination can be filed by any citizen whose name appears. What is the quorum to constitute a meeting of Lok Sabha? 1/10. The quorum is 1/10. All of you must have the idea. Let us keep it. 1/10 will be the answer. Answer will be B. Question number 9, BST 4 will be 1/10 of the total members of the House. But in state it varies. In state that is 1/10 or 10, whichever is higher. So, in Parliament it is 1/10. A resolution passed by Rajya Sabha under Article 249, the Constitution empowering Parliament to legislate on a state subject, national interest remain in force for a period of not exceeding 1 year. So, when a resolution is made for making any enactment on the subjects mentioned in the state list, then it will be yes, you are right, 9 is B. Okay, Panda, you are right, 9 is B, 1/10. Then a resolution made under Article 249 will remain in force for 1 year, not exceeding 1 year. So, that will be the answer, not exceeding 1 year, C. Next, let us see number 10, 11. Money bill in the Parliament has been defined by Constitution under Article, yes, 110. 110 contains definition of money bill. So, we are going through BST 4, we have 6 BSTs so far. 199 is definition of money bill in states. Are you getting my point or not? 110 deals with money bills at the center and 199 deals with money bills at the provinces. Okay, so answer will be B. Answer will be B. 11 is B. 111 is a very typical popular article, deals with veto power of the president. Okay. So, vote on account meant for vote on the report of the CAG to meet unforeseen expenditure, appropriating funds pending passage of the budget and budget. See, vote on account is followed when passage of vote is delayed or that surpasses the time limit for the financial year, and when the financial year begins the budget is not passed. In this scenario, the parliament can make an advance to the executive, to the government, and the advance is about 1/6 of the total budgetary outlay valid for 2 months. This mechanism is called vote on account. So, it is followed pending the budget. It is followed pending the passage of the budget, so that the government will be able to carry on day-to-day activities. So, answer will be C, vote on account. So, there is a vote of credit also. Vote of credit is a grant that for some projects whose prior estimation is impossible, that is called blank check. Vote of credit is a different thing, but vote on account is only during the passage of the budget. Okay, C. So, today there is no need for vote on account because budget is preponed. It is introduced in first week of February. So, usually by the end of March budget gets passed. If not passed, then vote on account can be adopted. So, there is a mechanism that vote on account deals with the expenditure side of the things. It grants money only, but interim budget sometimes a distinction distinguish between them comes in our examination. Interim budget is a budget which contains both expenditure and receipt column for a particular time period in a year, and interim budget is usually made by the caretaker government, the last budget of the outgoing government. So, there is a difference between vote on account and interim budget in country. So, it is C, answer will be C, vote on account. Okay, now we shall move to question number 13. Look at the question, which of the following are financial committees of Indian Parliament? 3 committees are financial committee, estimate committee, public account committee, committee on public undertakings. Others are administrative and other committees. So, answer will be A, B, C, option C. Answer will be C. They are financial committees. Estimate committee deals with budget, public account committee deals with report of the CAG, committee on public undertakings report the CAG, report of the CAG on public companies. Estimate committee was established in 1951 on the recommendation of John Mathai committee. Public account committee was there in Government of India Act 1919. Okay, it was established in 1921. It is a major committee, and public account committee has a special characteristic that the leader of opposition always becomes the chairperson of this committee. So, answer will be C. Okay, question number 13, answer will be C. Now, we shall move to 14. Which of the following courts in India are known as the courts of records? Court of record means that a court whose judgments or whose verdicts are preserved for perennial purpose. Under Article 129 and under Article 215, both Supreme Court and High Courts respectively are court of records. They have the power to punish for their own contempt. Their judgment will be preserved for eternal purpose. So, they are both court of records. The High Courts under Article 215 and Supreme Court under Article 129 are court of records in India. And court of record means their judgments are preserved for permanent value, and they can punish for their own contempt. Which of the following defines the duties of the that is Chief Minister? Sorry, it's not visible. Duties of the Chief Minister. So, duties of Chief Ministers are mentioned in Article D. Duties of Chief Minister towards Governor, that is Article 167D. And under 78, Prime Minister has the duty towards the President. Their duty means they will bring to the knowledge of the Governor regarding the affairs of the Governor, affairs of the government. It is a constitutional duty of the Chief Minister under Article 167 and Prime Minister under Article 178 to communicate to the President and Governors respectively regarding the performance of the government, regarding the affairs of the government. It is a constitutionally bound duty of the chief ministers and prime ministers. So, we shall now discuss 16, which is not true about Attorney General of India. He is the legal advisor to the Government of India, that is right. His tenure and salary is decided by the President. Not true. He has the voting rights in the proceedings. Yes, that is right. He has voting rights in the proceedings of the Parliament. That will be wrong. The Attorney General does not have the voting right in the House. So, answer is C, because he is not a member of the Parliament. Why does not Attorney General vote in the Parliament? Because he is not a member, simple logic. He is an authority who can sit in the Parliament during the discussion and debate, because he belongs to the government and he knows deals with the legal aspects of the government. So, anytime he is required, he can be allowed inside the Parliament in the well of the House, but he does not have the right to vote. So, that is also called rights of ministers and attorney generals. So, now we shall move to the question VST 5. Okay. How can a judge of the Supreme Court, question number 5, VST 5, question number 1, how can a judge of the Supreme Court be removed? By the will of the Chief Justice? No. By the President? Not alone. By the President on the recommendation of the Chief Justice of the Supreme Court? No. By the President on the recommendation of the Parliament. So, answer will be D. Answer will be D. Then who can attend either House of Parliament without being a member? The Attorney General of India, obvious answer. B. He can move to the House, as we have already discussed. So, let us move fast. Time is precious for us. Which of the following is not a feature of zonal council? See, zonal councils are established under, that is in 1956 7th Amendment Act provided for zonal council in India. Zonal councils, India is divided into principally 5 zonal councils: central zonal councils, northern zonal council, eastern zonal council, southern zonal councils and western zonal councils. All zonal councils are headed by, chaired by the Home Minister of India. So, ex officio chairperson of a zonal council is Union Home Ministers. So, it is established under State Recognition Act 1956 provided, and each zone has several states, like eastern zone we have Odisha, Jharkhand, isn't it? So, they have some headquarters also. Only central zone has headquarters in Allahabad. Others have their zonals in major cities, like Eastern Zonal Council has headquarters in Kolkata, Southern has in Chennai, Western in Mumbai and Northern in Delhi. So, these are the zonal councils. So, it is not a constitutional body because it is established under an act. So, answer will be A, because which is not a feature. Chandigarh, although not a state, is included in zonal councils. Yes, adjoining union territories are a part of zonal councils except Andaman and Lakshadweep. Yes, Andaman Nicobar Island only. Lakshadweep is there in southern zone. So, they are not included. The power of the High Court to issue writ covers constitutional rights because it is under 226. So, it is not a fundamental right like Parliament, like Supreme Court under 32. High Court has the power of writ under Article 226, which is not a fundamental right, it is a constitutional right. okay, mentioned in part 6 of the Indian Constitution. Very good question, tricky question. Okay, now we shall move to question number 5. The distribution of finance between central and state is done on the recommendation of distribution of finance. Distribution of finance is done on the recommendation of Finance Commission under Article 280. Okay, and the first Finance Commission was there in 1951, case in Aogi. So far 15 Finance Commissions have been set up in India to facilitate or to establish federal financial equilibrium. So that is Finance Commission of India, answer will be B, answer will be B. Dactylogram is related to fingerprint, it is a science that related to fingerprint, dactylogram, D. Okay, so this is the things of BSTs. Now we shall move to the next questions. The Vice President of India is elected by the members of an electoral college comprising all the members of Parliament, all the members of both houses of Parliament. In presidential election only elected members, but in vice presidential election that is all the members, both elected and nominated. Under which article the Constitution can the Governor refer to certain bills for the approval of the President? Under Article 200. Under Article 200, a Governor can reserve certain bills for the recommendation of the Presidents. Usually the bills are regarding DPSP, organization of High Court or any provisions that affect federal balance in India. The Governor may reserve certain bills under Article 200 for the recommendation of for the consideration of the President. Remember, President has absolute veto on the state bills. That is a unique provision. So Article 200 is the right answer, 8B. Parliament may legislate on any subject of the state list when, that is a repeated question ever, that is resolution thereof has been passed by the Council of States. Yes. So answer will be B. We have discussed it. The ultimate responsibility of taking due action on the comments of the Comptroller and Auditor General vests to it. The ultimate decision on the reports. The Comptroller Auditor General submits report to the President, and the report is analyzed by whom? By the Parliament of India. And in Parliament, the committee that deals with the CAG report is, yes, that is Public Account Committee. So answer will be C. Then the Indian Constitution vests the residuary power with, as we have already said, we have already discussed, the Union Government. Union Government, that is the things, A. Indian Constitution vests the residuary powers with the Union Government. I repeat, residuary power means the powers which are not mentioned in either list, which are not mentioned in any list of the Constitution. Okay, next 12. According to which article the Constitution of India, the Chief Minister is appointed by the Governor? So 164 will be the answer. 164, that is the under Article 164, it is provided that the Chief Minister shall be appointed by the Governor, and other ministers shall be appointed by the Governor on the advice of the Chief Ministers. The parallel article for Prime Minister is 75. So we have finished 5 BSTs, now the last BST, BST 6. Thank you very much for continuing with me. Okay. Which of the following committee or commissions are recommended for the creation of Nyaya Panchayat? Nyaya Panchayat was recommended by Ashok Mehta Committee, 1977. Okay, so that will be B. Baki all are constitutional committees. GVK Rao District Development Commission was recommended by G.V.K. Rao 1985. Balwant Rai, you know that very popular committee, 3-tier government. Sarkaria Commission is the first Center-State Relation Commission in 1983. Okay, it is the first Center-State Relation, RS Sarkaria Commission. It has a tremendous effect on Center-State relation in India. Then, in relation to offence described under section 175, 178, section 179 and that is your 180 and 220, 228. The Human Rights Commission act as a civil court. So section 180, 190, that is all are 170, 175 is omission to produce documents before a public servant. If we do not provide any document, then it is punishable. That will be done. Okay. Then 178 is to refuse to bind by an oath wherever it is required. If we refuse to take an oath, that will be a violence. That will be a violation of things. 179 is to refuse to speak the truth. So there are certain sections on which the Human Rights Commission can act as a civil court. So hence they are called quasi-judicial bodies for these provisions. Article, that is question number 2. Now we shall move to question number 3. The term of State Legislative Assembly can be extended during emergency by the Parliament. So during national emergency, the Parliament can extend the term of Vidhan Sabha and Lok Sabha for a maximum period of 1 year at a time. The first and last instance was 5th Lok Sabha was extended, and simultaneously the term of Vidhan Sabhas were also extended by 10 months or some days. So that was the only instance it can be extended by beyond the term, because election cannot be held. Then question number 4. In which country the concept of public interest litigation was originated? So obviously very good question. United States of America. Public interest litigation was brought to India by the effort of P.N. Bhagwati and others in 1980s. It enables the weaker section to have access to justice on behalf of others. So any public spirited person can file the case for public interest. Remember, it is not for private interest. That is a broader concept. So PIL has conceptualized judicial activism in India, and the court can take matters so motu also. And in PIL, locus standi is avoided, means the aggrieved person or the victim may not move the court. For the victims, other public spirited person can move the court. That is the rationale behind public interest litigation. So there is no locus standi. There is no locus standi. Okay. Then Chief Justice of India can be removed from his office by the President on the recommendation of Parliament, be it judges or Chief Justice. They can be removed by the President on the recommendation of the Parliament. That is the answer. So answer will be D. Chief Justice of India. The Parliament of India exercises control over the function of the Council of Ministers through adjournment motion, question hour, supplementary questions. So I think that will be all the above. Adjournment motion is allowed when an important discussion is to be held in the House, and during question hour the members put question to the ministers, they are answerable, supplementary questions. So all are the mechanism of ministerial control. D. Okay. Then question number 7. Which of the following statement is not correct regarding the control of parliament on a budget? Parliament does not have any role in the creation of the budget. Parliament has the power to move on the charged expenditure on the consolidated fund of India. Yes, Parliament has no power to impose a tax without the recommendation of the President. That is also correct. None of the above. So, that will be not correct. Does not have the creation. Parliament does not have any role in the creation of the budget. I don't think Parliament has any role in the creation of the budget because it is prepared by the executive. Parliament only approves it. So, none of the above will be the answer. What do you think? None of the above will be the answer. I don't mean what is the creation word means. D. Who among the following empowered to declare a geographical area as scheduled area under the Constitution of India? So, that is the Prime Minister, the President of India, the President of India, okay, the President, yes, answer will be D. Any area under schedule area, D. So, 5th schedule and 6th schedule area can be declared by the President. Sarkaria Commission was set up. I have already told you regarding this commission. It is a very important commission in India and it has tremendous influence on the center-state relation in India. Sarkaria Commission was established in 1983 and submitted its report in 1986. R.S. Sarkaria was a judge of Supreme Court. So, it was between the relation between the President, no. Relation between the legislative and the executive, no. Relation between the executive and judicial, no. The relation between the union and states, center-state relation. And the second commission that was appointed in 2007, M.M. Punchi. According to Citizenship Act 1955, by which of the following way a person can lose Indian citizenship? So, there are renunciation and termination. Renunciation and termination. So, that is the answer 1 and 2. So, answer will be 1 and 2, that is A. So, here is D, here is A. Okay. Now, a few questions remain. Which of the following not correct statement with respect to freedom of speech and expression in India? It is enshrined in part 3, yes. It is not an absolute right to express one's thought freely, not an absolute. It cannot be curtailed by legislation. It can be curtailed by legislation. Curtailed, not abolished. It can be curtailed. What is the next option? It can be suspended in emergency, yes. Article 19 can be suspended in emergency under Article 358 when national emergency is imposed on the ground of external aggression and war. So, there is a provision, okay, there is a provision that it will be suspended, but it cannot be cut, it can be curtailed. The thing can be curtailed, but cannot be abolished. So, I think it will be the answer C. Okay. Which of the following articles provides for the reservation of the seats for the scheduled caste and scheduled tribe? That is Article 243D. 243A is about Grama Sabha. 243B is about the constitution of panchayats at 3 levels. 243C is about the composition of the panchayats. So, they are all in part IX regarding the constitution. Okay? So, that deals with D, reservation. Reservation for SC, ST and women. There is 1/3 reservation, compulsory 1/3 reservation for women, isn't it? Then the parliament can make any law for the whole or any part of India implementing international treaties with the majority of the states, with the consent of the state concerned, without the consent of any states. Without the consent of any state. There is no meaning. 253, Article 253. Which article tells this? That is Article 253. international treaties implementation that state can give, the central government can give direction to the states regarding that. So that will be answer D, without consent of the states. Which one of the following models was suggested by the Ocs Mehta committee for the Panchayat Raj in India? Okay, the last question, I think. Yes. 3-tier model was not suggested, it was suggested by Balwant Rai. Mandal Panchayat is right, but 2-tier model is there. So better the option will be 2-tier model. See, Ocs Mehta committee was appointed in 1977 by Moraji Desai government. It is the first non-Congress government to appoint such a committee. Ocs Mehta had tremendous valuable recommendations for the strengthening local self-government in India. It recommended for a appointment of a minister for panchayat in the state level. It recommended for direct elections and constitutional status. In fact, it was the first committee to recommend for constitutional status for panchayats. So Ocs Mehta committee had valuable recommendation, but unfortunately they could not be recommended, they could not be realized, they could not be put into force because due to the uncertainty in the government at the center. Okay, but it had recommended 2-tier, one is Mandal Panchayat and another is Jilla Panchayat. So that was the recommendation C. So guys, that I have finished this BST. It is a small initiative for all of you by Vanik, the mega institution, and I have tried my best to give answers to these questions and also expanded the discussion on related options. I have tried my best. So time is approaching. Already you are on the verge of appearing the exam. I, from the core of my heart, wish you all the best for your upcoming examination. Stay calm always. Stay calm and stay secure. Okay, don't be confused. Don't remain in a confused state of mind. Okay, so be cool, stay home, stay prepared, and stay tuned to Vanik Smart Class. Thank you very much.